Tim Blankenship here with Divorce661.com, with the Divorce661 Daily Perspective, episode 48. This is where I talk live to you many times, but today we're recording, going over what I do. It's a little bit of training, mistakes you're making. If you're trying to do your own divorce, you want to watch these. I go over, when I said live, I meant this is a daily update. So it's fresh content, fresh information, as opposed to a video you might be watching that I did 12 years ago. So this is the most up-to-date information on the issues clients are having. Again, I'm Tim Blankenship. I'm a legal document preparer. I handle only divorce. That's what I specialized in for 12 years now. I handle cases all over California, whether you have a new case just starting from scratch or you have your judgment rejected like half our clients do. That's what I do. Let's get into the content. What I always do is go over what we did today. Lots of consultations, had 6 consultations today that were scheduled, but you can schedule consultations on my website. Go to Divorce661.com and schedule a call, and you can access my calendar and make sure I call you at the prescribed time. Of these consultations today, 4 were referrals. I mean, I would say a lot of our business is referral based at this point, and 2 are from YouTube, and a lot of our cases come from YouTube, which makes sense because we have so many videos out there. So anyways, I want to talk about 14 things that came up today. Lots going on, lots of cases filed, all that good stuff. So let's get into it. The first thing I want to talk about is the problems with our cases being approved so fast. I've done lots of videos where I talk about how we can have your case done in 5 weeks. And this is LA County specifically. Other counties, I can have your divorce complete in 3 months. So let's talk about the LA County cases. The reason we're able to do those so quickly is because of the e-file system. And this is why I tell you, if you're going to hire someone that does what I do, or anyone for that matter, make sure they're doing the e-file. Otherwise, your case is going to take just as long as everyone else's, 3 or 4 months. So with LA County, we can e-file your initial petition. That's how we start the process the same day. And we usually get those filed the same day, usually within a few minutes to an hour, and we have a case number. Following that, we draft your settlement agreement. I send out a worksheet to collect your terms and all that good stuff. And as soon as you guys sign that, we can get that ready for filing, and we can submit that at the 5-week mark. What happens when we get those filed at the 5-week mark? The court is approving those. They are approved by the court, and then the date, effective date of your divorce is written on there as 6 months out from when we got the process started, which usually is like 5 months later. So the problem that with us doing it so fast is in 5 weeks we're done, and then 5 months later when the final divorce date passes, it happened 3 times a day. That's why I want to talk about it. 5 months later when the divorce date passes, I get emails from my clients say, Tim, our divorce was done 3 weeks ago. I haven't received anything in the mail. I said, I gave that to you 5 months ago, the final divorce paperwork. And I tell that to them rather in the email, and send them their final copy, their final judgment. And they acknowledge it. They're like, thanks. I say, hey, make copies. This is your final paperwork. They acknowledge it. And then they still, not everyone, but a good percentage, email me, say, Tim, the date's passed. When do we get the divorce decree? And I'll say, that is your divorce decree. That's it. There's nothing fancier coming in the mail. That is your final stuff. So I wanted to go over that. It's kind of jokingly, that's the problem with us doing it so fast. People don't think that's their real paperwork, but it is. And so the next subject, number 2, what I want to talk about is what's the process when working with us? Like, what can you expect if you're a new client? And I'll go over it, and this is what that looks like. Usually it starts with a consultation, but it doesn't have to. Some people just outright pay us through the website, and I get them set up, and then the process is the same. You'll get an initial worksheet to provide me your basic information: names, addresses, date of marriage, date of separation, contact information for both parties, and all of that good stuff. And I get you set up in a portal called My Case. This is a third-party portal the attorneys use to coordinate whatever area of law they're in. And it's a way that we can communicate on a 3-way basis between you and your spouse. All documents that get uploaded, you get an email notification to log in so you can review documents. Where applicable, we can have you e-sign documents and all that good stuff. So that's step 1. Step 2 is I send out a worksheet, a template, if you will, that I created to collect the terms of your settlement agreement once you guys have discussed that, so you can provide those to me. Just the raw data. Who's keeping what? Is there alimony, yes or no? If so, how much and how long? What's the custody look like? Is there child support going to be involved, etc.? I help you with all those decisions, not from a mediated standpoint, but if you guys have questions, you need me to run numbers, through the court website to get child support or spouse support numbers. I do all that for you as well. Once we get the terms, we draft the final paperwork, the entire process start to finish. So we've already done the filing on the petition, and now we're going to do everything else. We're not going to break this up into several months. Many times this is done in a week or two. Keep in mind, if you guys get me the terms, we can get it done that fast. And then I'm just waiting until that 5th week where I can submit for approval. So we can move as fast as you like. Now, that's how we operate. I don't think anyone moves at the speed that we move to get your divorce completed. I don't break it down into little steps, file and serve and doing the disclosures and then the judgment and then I do everything after the initial filing. We finish all documentation after that. So that's what it looks like in working with us, working with both you and your spouse. It's a very fast, succinct process. The only difference is if you're not in LA County, you have to, and I can't e-file your judgment, then I just need you to mail in all your paperwork once I prepared it all so I can file it with the court at the appropriate time. Number 3, I talk a lot about default cases, and I want to talk about a lady I was talking to yesterday who was helping her daughter and all the problems she was having. And I mentioned to her that we've had, over the last 2 weeks, we probably had 4 mothers helping their daughters or sons with their paperwork because the kids were too busy to do their own divorce. And I assume the moms are retired because this is a very involved process if you're trying to help someone. And especially when it's not your own divorce, you don't know really what's going on. Anyways, she had watched our videos, tried to follow along and do all their own paperwork. And it sounded like they've been doing this for over a year. And I didn't have copies to review. I usually, when people call for consultations, I can see online what documents have been filed, but I can't see what's on them. I can't see the images of them, but it gives me an idea of what's going on. And so I was having her talk through the judgment. Now I recall had been rejected twice. And as I'm going through the documents and hearing what she's saying on the reject sheet and the forms that we're going over, there's just little things that she missed that's causing but it was many things. There's probably 12 things we went over beyond what the court said was wrong with her paperwork that in the future was going to continue to reject her judgment because, as I said so many times, the court doesn't do a full review of your paperwork each time. They will do a few reject items, send it back, you fix them, and they turn it back in, it gets rejected again. And that's what was going on with her. So that's why we take over cases. 50% of our client base is people that we take over their divorce case for them. Definitely take advantage of that. Our costs we have flat fees. I think we're a very affordable way to go. And we have same day service, which, as I said, I think I skipped right over our divorce filing today. We had clients that hired us, today's Thursday. We had clients hire us on Monday, pulled all their paperwork from court, finalized their paperwork on Tuesday. They e-signed it. And e-notarized it today, and I e-filed it this morning around 10 a.m. And by 1:30, we had their judgment approved by their court. And this was a 2021 LA County case that we finalized in 4 hours. So they're very, very happy. And you can have the same. I don't like selling like that, but we can do the same for you. Number 4, consultations. Consultations are not required as long as your case is amicable. This includes being able to start from scratch or finalizing your divorce. So like I said earlier, people hire us without us ever talking to us. And the first email I'll send them say, hey, got your information and your payment. Just, as long as you guys are amicable, cooperative, and you guys will sign off on everything. No worries. We'll get started and handle your case. So feel free to retain us and get the ball rolling. Really, when I'm doing my consultations, I'm answering your questions about our service, and I'm also asking you questions to make sure you're a good fit and that we'll be able to finalize your case. Because as you know, I don't want to take anybody's money. I don't think we're going to be able to finalize their case. All right, number 5, Alameda Court e-filing of a summary dissolution that they rejected partially. So the courts are slowly coming. LA County is 100% online, start to finish for your divorce. We can e-file your petition, every document, including your judgment. It's a beautiful thing. Some of the courts are slowly coming in online for e-file. Most of them only allow you to file the initial documents. So Alameda, I saw that they would allow us to file the initial documents, including this summary dissolution. So I e-filed the summary dissolution and it got rejected. And the notes from the clerk were that you can file the petition, the summary dissolution, the petition portion, but you can't file the judgment portion, which is just a 2-page form. So they rejected it for that reason. And they said you need to put the second party as the petitioner, not the respondent. Here's the issue with that, Alameda. And I wrote the letter to you today, so you should be getting it. Hopefully you actually read it, because I did a schematic and I did highlighting and pointed arrows about what's wrong with your e-file system. So the e-file system would not allow you to select both parties as a petitioner as it does for, say, LA County. In LA County, when you file the summary dissolution case, both parties are listed as a petitioner, which is correct. On the Alameda e-file, it would not allow me to select petitioner. It would let you select it, but when you submitted it, it would reject it and say, you need to select, there's no respondent selected. There's no respondent in a summary dissolution. The other problem I had with Alameda County, it made this a total waste of time, is why would I e-file just the petition, get a case number issued, and then have to mail in the judgment portion separately? And I tell you why it is. Because when you do a summary dissolution, once it's approved, they need to have 2 envelopes, one to mail the copy of the final judgment, which again is 2 pages, to the parties. They can't seem to do that. LA County does. It just gets frustrating. Lately, I noticed my videos are of frustration, but just know that if you're trying to do your own divorce, and I know what I'm doing, but you don't, in most cases, you're going to have more trouble than I am. Number 6, why you should e-file your judgment. So, the gal I talked to earlier who was trying to do her daughter's divorce, every time she turned in the judgment, it would take 6 weeks to get back. And I said, how are you filing? And she said, I'll go down to the courthouse and actually hand them in. I said, okay, well, that's why it's taking 6 weeks. That used to be 3 months, by the way, so it's still not bad. What I told her is, if you were to hire me, I would take over, finalize all your paperwork, I would e-file it. And like the case I filed earlier today, we had approved in 3 hours. 3 hours versus 6 weeks. You tell me what's better. People like to, I understand it might be about the money sometimes, but when we take over your judgment and your final paperwork, it's $800 currently as of February 1st, 2024. If your time is not worth more than that, then spend the time. This was a year-old case. Spend the time struggling. I'm not hoping you do. And I know not everyone hires us, but like this person I spoke to yesterday, I probably could have their judgment submitted today. That's the difference in doing your own divorce versus hiring us. Number 7, talk about children born before the marriage. If you have a child born before the marriage, you need to attach a declaration of paternity when you turn in your judgment. So, and you're going to attach it to the FL 170. So every time I have a case with children, I have to look, when I see the date of marriage, I have to check and verify that against the date of birth of the children. And if the children are born before the marriage, I have to ask the clients to provide me the declaration of paternity. This is a form you would have received in the hospital at birth. 99% of the time, you're not going to have it. You did get it at birth, but I know you probably misplaced it, lost it, didn't think it was important, what have you, because you're worried about the birth certificate. So I'll say, hey, do you have the declaration of paternity? They'll say no. They say, why do we need it? The father is on the birth certificate, and that's completely different. You might be the father is listed on the birth certificate, but in the court's eye, you're not the father until the court establishes that. So that declaration of paternity is a document that I draft, a separate stipulation that says that you acknowledge being the father of the child, as does the mother, and that you take care of the kid, basically. We attach that to the 170, the declaration of default. And that if you don't turn that in, then the court will not allow you to establish parentage of the child, and they'll reject your judgment. There's a lot that goes into a divorce. You guys think everything's easy. Just even if it's a simple no asset, no debts, you have kids, no alimony, no child support, this issue alone about the paternity will cause your judgment to be rejected. And then you're going to go to the county trying to find a declaration of paternity when I can draft one up in 30 seconds. All right, number 8. I'm going to talk about our flat fees and how I am proud to say that if you pay our flat fee, I will get your divorce done, even if it turns into a total mess that I was not expecting. I have never gone back and asked clients for more money ever. So I have flat fees. I've had them for the entire 12 years we've been doing this. I never have gone back to a client for more money, and some of them have turned into a total mess. But guess what? It evens out. I have cases that end up to be super simple, way simpler than I thought, But on the other end, I have some that turn into complete messes that take months to finish because of hearings or things that are going on, court delays. I have to do extra paperwork, multiple changes. I've never gone back. I feel like it's bad faith to say it's flat fees, and then I charge, if there's something else I need to do, I charge extra on. I just don't do it. If you hire me, what I say you're going to pay is all you're going to pay, and we'll get it done. Number 9, what happens at a status conference? So most of the courts will set status conferences, hearings, where they want you to appear, or a lot are by telephone now, that if your case is not moving forward, that they will call you up, or you'll get a notice of a hearing, and it's a status hearing. What's the status? That's all they want to know. It's like my clients when they want an update. What's the status of my case? That's all they want to know. If you don't, so some courts, they will set automatic hearings. When you file a petition, you'll get a form that says, hey, there's 3 hearings scheduled over the next 3 years, just to keep, make sure your case is moving. Some don't. LA County doesn't do that. They don't set automatic status conferences, but they have an internal kind of trigger, if you will, on certain instances. So the first one I've noticed is usually at about 2 months after you filed your petition. If your spouse hasn't been served by that point, it'll trigger a hearing. You'll get a notice, and then within 45 days or so of that, there'll be the date of the hearing, and they're saying that they're just calling now. They'll call you on the phone from the number listed, and basically saying, what's the update? There will be a judge, there will be the clerk, it will be in the courtroom. But like the client asked me today, like she purposely was not serving her spouse because they are still working on the terms, and she didn't want to let him know that she had filed for divorce yet. It's just the way she wanted to do it. So she got this notice because it's been filed. It's been about 2.5 months. So I said, no big deal. Just take the call, let them know why you're purposely not serving it, and that yes, he eventually needs to be served to move the case forward. The next time you'll get a status conference hearing is if your case has not progressed or finalized after, say, month 4, month 5. If the proof of service has been filed, the next tickler, if you will be the notice to enter default has now been filed. That'll trigger another hearing, whether you either have to come in, or they'll call you to say, hey, your divorce isn't finished. You need to come to this hearing or file the request in your default before that happens. 99% of the time, our clients never get a notice for a hearing because we've already finalized their paperwork in like 5 weeks or 3 months or what have you, including the proof of service judgment, the whole shot. So generally that's not happening. Sometimes people will call us that haven't hired us, say, Tim, I got this notice. Can we find, what do we need to do? I said, well, let's just finish it up and have it done in 2 days. And then the hearing completely goes away. All right. Number 10. My notes. What does the divorce decree look like? Do you get a certificate? Okay. So when you sign your settlement agreement, that is your judgment. That is your settlement agreement. The FL 180 and all the terms, whether you use the forms or you use the settlement agreement, that is your final divorce judgment. It's also your final divorce decree. I will send out our approvals to our clients, and they'll say, okay, when do I get the certificate? I'm so like, what certificate? They said, well, like a marriage certificate. Do I get a certificate with like a seal signed by the clerk, by the judge? And no, you don't get anything fancy like a marriage certificate. It's not anything. They think that the judgment is not official enough. The FL 180, that it contains your terms, the custody order, the child support order, the spouse support order, property division, all that you guys sign and notarize, the judge then signs that right below your signature. That agreement is your judgment. And that is it. There's nothing fancy you're going to get in the mail. I always laugh when they ask for a certificate or something fancy because it's just not as exciting as they thought it was going to be. Number 11, simple mistakes can set your case back. Had a client who filed their own divorce a year ago, February of 2023, so almost a year ago. Yeah, a year ago. And filed it, served it, and then didn't make any progress on the paperwork. Called me this week, had a consultation considering hiring us. I had her send over her paperwork, and I said, well, unfortunately, your petition has errors. They didn't address spouse support, and their summons had an error because they didn't list their address on the summons. Yes, that will cause your judgment to reject. I know the court filed it, and you think you're good to go, but they don't look at it. They just file it. I tell you that all the time. So I told her we need to amend it. And she's like, okay, if we have to, we have to, and we do have to, because if we just continue, if I didn't review that and I just continued on, they're going to reject it saying spouse support was not addressed in the petition, and the summons didn't have the petitioner's address where it says address of attorney, because you are your own attorney if you don't have one. And that's why the address needs to be on there. So the problem with that is we have to amend our petition. The other problem with that is it's Sacramento who doesn't have e-file. So this is just going to cause a huge delay in her case, which has already been going on a year. So I amended her petition and summons. She's going to sign it. I need to mail it to the court because they don't have e-file. They take 2 or 3 weeks to file that, get it back to us. And then the respondent needs to be served again, even though they were served a year ago. And then we have to wait another 30 days to be able to turn in the judgment. So as I say, if you can and you find me, start with me from scratch. If you know about me and you file your own case and you mess it up and I have to amend your petition, and you've served, like in this case, we have to basically start over, refile, reserve. Happens a lot. Number 12, questions on a consult I had today. Why do I make the process sound so simple? So the person I spoke to today, they said they had called multiple people, talked to lots of attorneys, and got their quotes of $3,000, $3,500, $5,000, and they said, "Boy, they sure made it sound so complicated. Why do you make the process sound so simple?" I said, "One, I'm not representing you. Of course, they're going to give you this long, drawn out process." So she goes, "Yeah, they said we have to file and then hire a process server, and then we have to what sounded like not just the regular disclosures, but to like investigate the person's finances." I don't do that part of it because it's not required where parties are amicable, but when people hide assets, you have to do that. So they brought up all these other things that they had to do, and then this other party needs to respond, and then they need to do their discovery. Like they were going to file for discovery. You don't need to do that when parties are saying, "Here's our assets and debts." So when I went over my spiel, if you will, of how I handle things, and I went over that earlier in the video, it's a totally different process when you're amicable, cooperative, and you have one source, one neutral third party like me handling your paperwork. We usually have your paperwork done in a week. If it's LA County done, your divorce is approved in 5 weeks. If it's every other county, we have you approved in 3 to 4 months, depending on how slow the court is in processing your judgment. So that's why I'm not making it sound so simple. It is that simple. Number 13. My notes say here, when you're not exactly amicable and involving a third party might make things not amicable. So I had a consultation today, and the wife said, yes, we're amicable, but he's narcissistic and controlling and all these other things that for me are red flags. Because as soon as I hear that, I'm like, I don't want anything to do with this, because the likelihood of this going through smoothly is very unlikely. I said, but when I hear things where parties have fear of, I said, here's what basically I said. What do you think if I just work with you? Because normally I work with both spouses from the very beginning. Everyone's on the same page all the way through the process. In this case, I said, look, because of the narcissism and other things you said about him, it might be better that I just work with you directly. I'm totally out of the picture as far as he's concerned. All he's going to think is, wow, you did a really good job completing this paperwork. And so what we're going to do is we're going to do the filing, and then we're going to do all the remainder of paperwork from start to finish, the whole process, including the settlement agreement. And then she's just going to go at a time of her choosing when he's in a good mood or whatnot and sit down, and they can just sign everything in one shot and call it a day. Number 14, I'm going to talk about when clients get mad at me and why, when they get mad at me and why they do. We communicate all through a third-party portal called My Case, so everyone's on the same page. Everything's on the up and up. No third-party conversations, and so no one feels like anyone's talking about someone's back. This week, I had 2 cases where husbands were upset with me because the case wasn't moving on, and I was trying to explain to them, look, your spouse is not participating. They're not doing the things they need to do. Something was going on. What turned out behind the scenes was they were emailing each other off of our portal, so I wasn't knowing what's going on. But in both cases, you women, usually it's the men, just so you know, were saying that I was saying things to them that then they were saying that, saying to their spouse that I was doing that was causing the husband to get mad at me. So, and I was getting confused, like, what's going on? I don't know why are there issues? In both cases, I called them both up and said, look, here's the issue. One is your spouse is playing games. That's why she's not signing the proof of service. That's why she's not signing the settlement agreement. It turns out she wants child support all along, and he was surprised to learn that, because she was playing games. The other one, the husband did something that I don't want to reveal that upset the wife. And then he was mad at me because the case wasn't moving forward. The reason it wasn't moving forward is because she's thinking about getting an attorney for something the husband did. So as I say, in closing, the only thing that can stop your divorce from going through is you. If you guys are amicable, cooperative, we'll sign off on everything. We can get your divorce finalized in California. Hope you're having a great day. Thanks so much for watching Daily Perspective, episode 48. We'll talk to you tomorrow.